although it introduced a few additional safeguards in those cases, what we've seen is the inherent ambiguity in these definitions have meant that the tracks themselves as concepts or as different categories are very difficult to maintain because people seem to switch tracks. So, for instance, someone that might seem to be in track two because they are living with a chronic condition or a disability rather than a terminal condition is suddenly being considered to be track one and thus subject to less safeguards because they are in a certain situation declining medical interventions that could help manage their chronic condition and who are dealing with a mental illness. We've seen really egregious cases of this play out in the case studies documented by the Ontario Coroner's Office MAiD Death Review Committee. So what we see in terms of the letter of the law that we compare is that when you lack that objective criteria of a prognosis, for instance, you create these inherent ambiguities that can lead to a lot of wide interpretations and ultimately into increasing number of Canadians receiving an assisted death whom the legislation was never really intended to include in that eligibility criteria.